Okay, so the next thing that we need to do is talk about investigations. So for those of you who might be skipping around with these videos, when I'm talking about investigations here, I'm talking about investigations that are undertaken by what is referred to in the Uniform Law as the local authority, which means in the case of Victoria, the Legal Services Commissioner. And we want to look at when and how the Legal Services Commissioner investigates complaints that might or that involve an allegation of unsatisfactory professional conduct or potentially even professional misconduct. So most complaints are generated by either clients of the lawyers, or they might be generated by, a complaint might be made by a third party who's somehow involved in a transaction, and the commissioner is generally required to investigate a lawyer's conduct if a complaint has been made against them. But the commissioner can also initiate a complaint about the conduct of a lawyer, even where no complaint has yet been made or is ever going to be made. These have the rather charming but unimaginative title of Commissioner Initiated Complaints. Who would have guessed it? I know most of you won't have done admin, so I don't want you to get too caught up in this idea, but I'm going to mention it over and over again, is that in conducting investigations, it is important that the Commissioner observes procedural fairness. And the standard of proof to move from an allegation of unsatisfactory professional conduct or professional misconduct will be the reasonable satisfaction. So this is referred to as the Briginshaw standard. And you'll get a lot more detail around that in Del Pont in chapter 23. So in Briginshaw, the High Court held that where a civil case involves allegations of criminal conduct, fraud, or moral wrongdoing, which may lead to grave consequences for the defendant, then the judicial approach should be a closer scrutiny of the evidence. In other words, the Briginshaw standard is a high standard of proof. It's not enough to just make an allegation and go with the vibe, because the consequences of a finding of unprofessional conduct or professional misconduct are grave consequences, then the onus is on the person seeking to demonstrate that that allegation is true is a high one, and so the standard of evidence required is high. Have a look at Del Pont in chapter 23. He provides some more detail about the process of the disciplinary proceedings, and in 2375 he discusses the need to avoid bias. And in 2380 he also has some pretty interesting stuff about costs. So costs must be ordered against a lawyer found to have engaged in unsatisfactory professional conduct or professional misconduct unless exceptional circumstances exist. And this kind of reinforces this requirement for the Briginshaw standard. So when will the Legal Practice Board and Commissioner, or actually the Legal Practice Commissioner, initiate an investigation? So a commissioner-initiated investigation will be undertaken in a number of circumstances that will include the following: where a disciplinary complaint is withdrawn, but the commissioner considers that the investigation should continue. So the client might have had enough, might actually not want to pursue the matter any further, but the commissioner thinks it's worth pursuing. They will also initiate an investigation following receipt of a trust account investigation report, or a referral by a judge or a magistrate about a lawyer's conduct in court. Sometimes investigations are initiated following the identification of improper conduct of a lawyer based on a media article, newspaper article, or something on YouTube, or even Facebook posts. Well, actually, Facebook I'm just assuming lawyers are old and use Facebook. It might be a TikTok or a Snapchat, who knows. They would be bundled into that media idea. Following the identification of improper conduct in an investigation by the Commissioner into some other conduct. So if for example, the Commissioner is looking at the conduct of a practitioner who is in a legal practice, and as a consequence of that, is looking more systemically at what's happening in the legal practice or what is happening with other lawyers in that practice, they may initiate a further investigation. Or sometimes the Commissioner might receive a report from another agency. So, for example, the Office of the Public Prosecutions about a criminal prosecution involving a lawyer. Following the investigation, the Commissioner has a range of different powers that they can exercise. So if a Commissioner is satisfied that the lawyer would be found guilty of unsatisfactory professional conduct, then the Commissioner can issue a caution or a reprimand. They can order an apology. They can order the lawyer or the law practice associated to redo the legal work at no cost, or to reduce or to waive the costs for the work that they've done or that they will do. They can make an order for further training, education, counselling or supervision. They can issue fines up to $25,000, and they can bring charges against the lawyer before VCAT. And so following a hearing, either VCAT or ultimately the court can issue a reprimand, suspend the practitioner's practicing certificate, or strike the practitioner off the roll. In other words, removing or disbarring the solicitor or the barrister. So a couple of things to notice here. The Commissioner can't suspend or take away your practicing certificate. They need to refer you on to VCAT, and you have a right of appeal from VCAT ultimately through to the Supreme Court and to the High Court from there, I guess. And so it's only VCAT or the court that can suspend or strike the practitioner off, suspend the practicing certificate or strike. So you can see that there is a kind of increasing order of seriousness, and usually the harshest penalty, the striking off, will be reserved for the kind of dishonest behaviour which renders the lawyer not fit and proper to practice. Again, go back to Del Pont towards the end of the chapter 23, paragraph 100, 110, he has quite a lot of detail there. Following on with factors that will be considered will include the frequency of the misconduct, the attitude or the remorse that the practitioner demonstrates, the level of experience that the practitioner has, and they take things into account like illness, including mental illness, addiction, other stresses. So again, this is pretty neatly tied up at the end of chapter 3, paragraphs 115 to 150. And we're going to, in the next video, which will probably be the longest one in this section, we're going to look at a number of those examples that Del Pont goes through and that come up in your other readings, so that we get a sense of really how to answer that question: when will the harshest penalty apply? When will a lawyer be struck off?